Imagine being a foreman on the job doing tough, hard work day in and day out, and you get injured picking up a 5-gallon bucket of cement. But then your injury is so bad, you're suddenly unable to continue working at all. But what's worse of all is that when you went to the insurance company to file a claim for your medical bills, they denied you. Well, that's exactly what happened with one of my clients, a young man in his 30s who suffered an injury on the job. But what makes this story interesting is not that he was awarded a $400,000 settlement, it was why the insurance company was fighting him so badly. He was lifting 5-gallon buckets of cement and felt pain in his lower back. He was sent to an urgent care 3 weeks later and was referred to a specialist. The specialist he was sent to told him he was fine. He was sent back to work but still in pain. My client was sent back to the same doctor and again was told he was fine. My client was finally sent to another doctor who ordered an MRI of his lower back. That MRI showed a tumor on my client's back and was told he needed it removed immediately. The insurance company denied the claim, stating my client had a pre-existing condition. I was able to argue that although the tumor was not caused by his job, the injury at work to his lower back did aggravate the tumor, and my client did suffer disc disruption at other levels of his spine due to the injury. I was able to obtain a new treating physician for my client and get him surgery he needed. The insurance company initially offered $50,000 plus a Medicare set-aside of $55,000, as my client was on Social Security disability. I was successful in getting my client a settlement of $386,000 plus the Medicare set-aside of $56,000. I'm Craig Armstrong, and since 1983, I've been helping Tulsa area residents who are injured at work get the proper compensation they're entitled to. If you've been injured at work and have an insurance claim or a Social Security claim and are being pushed around, visit my website and set a time to meet with my firm. Also, if you need more information about workers' compensation, check out the rest of my videos on my site and channel. Unfortunately, people with pre-existing conditions are injured every day. When you have a pre-existing condition, when it comes to workers' compensation, the law states you must show you have sustained an identifiable and significant aggravation of a pre-existing condition incurred in the course and scope of employment. If you are hurt on the job and file a claim, it is also important to know what to do and what not to do in this situation. The first thing you want to do is be careful what you say and who you say it to. You do not want to say something to a coworker or your employer that is not correct or can be taken incorrectly. Next, you need to report your injury to your employer and make sure you include all injured body parts, regardless of the degree of severity. Many injuries can take hours and days to fully manifest themselves after the initial trauma. Once you report your claim, you need to get medical treatment. If your employer does not provide medical treatment after reporting a claim, you should seek medical treatment on your own. Contact my office and set up a meeting to file your claim with the Workers' Compensation Commission. But more importantly, here's what you should not do and why. Do not discuss your injury with coworkers. Innocent comments can always be misconstrued. Even though you may feel your coworkers are your friends, when it comes to job security, these friends could turn into company witnesses if the choice is keeping a job or helping a friend. Do not decline to see the company physician and see your personal physician instead. If you sustain an injury at work, your employer is responsible for providing medical treatment. If your employer offers you the opportunity to receive treatment and you decline and elect to seek care through your own physician, you may be responsible for those medical bills. And your employer may argue that you are receiving unauthorized medical treatment and decline your claim. Do not consume alcohol or illegal drugs, including marijuana, within 24 hours after reporting your injury. This also includes medical marijuana, even though you may hold a medical marijuana card. Many employers have injured workers undergo a drug screen after reporting an injury. If alcohol or any other medication was taken immediately after your injury, but before the drug screen, there is no way to disprove the substances were not on your body at the time of the injury. Be mindful of what you post on social media. Pictures posted on your Facebook or Instagram page can damage your claim. If you are claiming an injury, do not post vacation pictures of you doing activities involving your injured body parts. If you need more information about workplace injuries or Social Security claims, check out the rest of my videos on my channel or website. We make videos like this educating workers of all their rights when it comes to workplace injuries or Social Security claims. If you've been injured at work, schedule a meeting with us today and let us help you create a plan to get the compensation you're really entitled to. I'm Craig Armstrong, and I look forward to helping you.